I'm Susan Bryson, chair of the philosophy department and director of the East Wheelock program, and I'm delighted to introduce today's speaker, Professor Victoria Nourse, who will be given this year's Roger S. Aaron Lecture. The endowment supporting this lecture was created in 1996 by the Dartmouth Lawyers Association, an extraordinary group of alumni who went on to careers in the law. And it was created in honor of Roger S. Aaron, class of '64. I'm sorry to be the bearer of the sad news that Roger Aaron passed away earlier this year. And I just want to extend my deepest gratitude to him and to the Dartmouth Lawyers Association for all that they did and continue to do to support legal studies as part of the liberal arts curriculum at Dartmouth. I'd also like to thank Jennifer Fleury, who is this year's convener of the Legal Studies faculty, and the Nelson A. Rockefeller Center for Public Policy and the Social Sciences, especially Andrew Samwick, Sadhna Hall, and Joanne Needham, for all they've done to make today's lecture possible. Today's Aaron Lecture, Professor Victoria Nourse holds a BA from Stanford, a JD from the University of California at Berkeley, and began her legal career in New York, clerking for Judge Edward Weinfeld and practicing at Paul Weiss, Rifkin, Wharton, and Garrison. She left private practice to serve as a junior counsel to the Senate-Iran Contra Committee, and from there, she moved down Pennsylvania Avenue to argue appeals for the Department of Justice in the Reagan-Bush years. Professor Nourse concluded her career in practice as senior advisor to Joe Biden, who was then chair of the Senate Judiciary Committee, working on a variety of legislative matters, including the Violence Against Women Act. Now, that's the very modest statement that you see if you look up her bio on the Georgetown Law Center website. But in fact, she did more than anyone else to draft, really write, polish, and lobby for the Violence Against Women Act, which was finally passed in 1994 and is currently up for reauthorization by Congress. But this is an extraordinary accomplishment in and of itself. She's currently professor of law at Georgetown University, where she's also director of the law school's first Center on Congressional Studies. She came to Georgetown after holding endowed chairs at University of Wisconsin and at Emory University, has been a visiting professor at Yale, at NYU, and University of Maryland law schools. Her most recent book, In Reckless Hands, tells the story of a 1942 Supreme Court case striking down state eugenics laws, a case that announced a right to marry and to procreate. Professor Nourse has published very widely in many of the most prestigious law reviews on constitutional history, the separation of powers, legislation, and the criminal law. Her latest article on Congress, A Decision Theory of Statutory Interpretation, appeared just this fall in the Yale Law Journal. She's currently at work on a book entitled Notes from the Legislative Underground, which addresses the emergence of women's issues in a Congress with few women, very few women at the time, explains why the 1994 Violence Against Women Act was so difficult to pass in spite of broad bipartisan support, and speculates about why women's equality issues have resurfaced today in the so-called war on women. Her talk today is drawn from this project, and it's entitled Backlash Revisited, The Lost History of Legislation on Violence Against Women. Please join me in welcoming Professor Victoria Nourse.
Thank you, Susan, for that overgenerous introduction. I often describe my career by simply saying that some people can't keep a job. I need to take a moment to thank the Aaron family for endowing this lecture, and as well to thank the Rockefeller Center, which has been, so many people have been wonderful hosts. I met this morning with the director, Andrew Samwick, and I learned very much about how government is taught here, and I'm pleased to say that I'm happy to come back anytime. Thank you to the Deputy Director Sadhna Hall, Joanne Needham, who I needed her, and she was there. It has been a very, very busy couple of days, but one that has been very productive. Now, the lecture I'm about to give, I hope, is informative. It may be a little bit shocking, but I hope it'll contribute to your understanding not only about the Violence Against Women Act and its lost history, but as well to an understanding of the Congress and how it has dealt with these issues in the recent past. Now, as a point of personal privilege, which is what they say in the Senate, I would like to dedicate this talk to a stranger whose sacrifice touched me. First Lieutenant Ashley White Stumpf was 21 years old. She died in Afghanistan. She was part of Special Forces. She was part of Special Cultural Forces. And she was charged with going places where no SEAL or Marine could manage to infiltrate. She was charged with infiltrating, essentially, and a society that, not with bricks, but with fear and cloth and secrecy and sex segregation, was harboring violent dangers to our forces and cloaking them in the guise of women. These cultural forces were intended to protect the forces outside where she was working, but unfortunately, she was killed as she was trying to fight these barriers of violent reprisal against the people who our forces were trying to aid. At the end of the lecture, I'll try to explain why I have sought to invoke her name. But let's begin at the beginning. It has been said by some, including Susan Bryson, that I wrote the Violence Against Women Act. Well, my most proud possession is a copy of S11, the first version of the 1990 Violence Against Women Act. And on it, I have goodbyes from the members of the staff and senators who I worked with as I was going off to academia. And then Senator Biden, now Vice President Biden, wrote on there for herself, where it says, Senator Sarbanes, Senator Biden, etc. But that's not true. I stood on the shoulders of many. And anyone who knows anything about the Constitution knows that nobody elected me as a staffer. And it is those who are elected who are charged to speak in favor of others, to represent the views of others. I was but the channel. Senator Biden made all the decisions. And I will tell you that it was I knew at the beginning that as the chairman of the Judiciary Committee, this was something powerful, because this was someone who could command the respect of a number of members of the Senate. So yes, the true story of the Violence Against Women Act is that I was in the room. I was the only woman in the room. This was a year when there were only 2 women senators, 1990. And Senator Biden said, Vivica, Virginia, Victoria. True story. Valerie. Why don't you try your hand on something on women and violence? We were part of the whole legislative staff. We were working on a number of complicated issues. I was hired to deal with a complicated reform of habeas corpus recommended by the Supreme Court. And when I asked him, I said, well, Senator, what exactly would you like to do? He said, well, Birch Bayh and I did something reforming the federal rape law. Go look at that. And promptly went off to the Foreign Relations Committee. So what was I supposed to do at that point? Well, it wasn't the first time that I had been the only woman in the room. I had been brought to Washington by the renowned lawyer Arthur Lyman, who was known for his humanitarian impulses, his extraordinary service to the legal community, breaking the strike at Attica, and for having Carl Icahn sleep on his couch at Paul Weiss Rifkin Warden Garrison. I was just out of a clerkship, and on a Sunday morning he asked me to come to Washington, why I was there at all, to serve the now vice president. He asked me to work on the Iran Contra investigation. Now, some of the senior associates were a little bit suspicious, and I remember one of them coming in and saying, being very angry with me and saying, "You don't have any foreign policy experience. Where are you going?" And I knew in the back of my head why I was going. But I said, well, Arthur had asked me, and of course I couldn't say no. And I knew I billed a gazillion hours like most associates. But I also knew that at the appearance level, I looked the part. You see, Fawn Hall, who was Oliver North's secretary, had been alleged to cover up the Iran-Contra hearing by taking some documents out of the old executive office building. And one senator alleged, his name was Howell Heflin, a former judge, distinguished judge, Democratic senator from Alabama, alleged that she had taken them out in her bra. Documents in a bra. Well, she contended they were in her boots. I'm not so sure that makes it any better, but she claimed that Senator Heflin was a sexist, and this was bandied about quite a bit in the Washington papers. Yes, I had billed those hours, but I'd also had the ability to take Fawn Hall to the bathroom and, seated right behind Lyman, show the world that the committee was not sexist. So yes, I had been the woman in the room. And what I had learned from that 3 years later was that genius is 1% opportunity and 99% hard work. So I knew I had an opportunity in my hands, and I also knew that everybody in that room could have done it just as well as I could, perhaps even better. I was there with Ron Klain. He would later be depicted by Kevin Spacey in the movie Recount, chief counsel to Al Gore and Joe Biden, their chief of staff as vice president, and far more politically savvy than me, and a great supporter of the Violence Against Women Act, indeed, one of its original experts. But who was actually to go do the work? Well, I was the low man, low woman on the totem pole. So I needed to do as much as I could do to make this the best product for my client. Senator Biden was my client. But I did what no self-respecting Senate staffer usually does. What I did was what a future academic would do. I went to the library. Usually you'd call other staff and ask them what they had done, because there's a theory of precedent that actually operates not only in courts but in Congress. If you've already done it, you've had the vote, so you want to repeat it. Well, I had kind of assumed, other than this Birch-Bayh bill that I had heard about, that there wasn't much done, and in fact that's true, and I'll go on to explain why. So I went to the library, and I had to find some women. Since there weren't any women in the Senate, right, I had to find some women. So I found them on the shelves. These are women who had been writing about women's issues for years and on whose shoulders I would stand in the days that would come forward. And so I educated myself over a period of, I know this sounds really short, but it's an eon in Senate life, about 10 days. I once read that senators have 7.5 minutes a day to read. I've never found anything to support actually that, but someday I'll find the citation for it. I do know that time is a precious, precious commodity. And so I skipped out of the office during a recess when everyone was home campaigning, went to the library, and worked on a proposal. It was in the March of 1990, during that recess, that I found these women on the shelves who would tell me what I needed to know. Unfortunately, they were often very, very sad stories. Very, very sad. These were cases of women who had largely been abandoned. It was depressing work. Women who had been beaten, women who had been sexually abused, sometimes done supposedly under the name of love. And I had to translate that to someone I barely knew, a boss I barely knew, a group of men I barely knew, and a Senate that only had 2 women senators. But you know, I have to say that despite the difficulty of the topic, I knew at the time that I had been given something precious, because I had been given an opportunity that I knew that even my sister, who is about 7 years older than I am, she never would have even thought to go to law school. She never would have been standing in that position in 1990. And I felt, I think, much like Felix Frankfurter is said to have thought. He was, of course, an emigre, and he was a first-generation American, and he used to run up the steps, apparently, of the Supreme Court and whistle the Star-Spangled Banner. And I too, even though it was very depressing and call it sappy, I felt the keen awareness of a privilege vital to its holder precisely because it was fragile and new. A privilege that was the accident of time, of my generational position and my birth order. I was born at a moment where I was the naive beneficiary of what I considered a precious commodity, the opportunity to serve my country. I was part of a shattering generation, a woman old enough to remember the woman's only entrance, yes, at my father's Boston club, who, when she asked her father what she could be, he could only say a secretary, but who thought it was pretty tough and cool and smart to pay for her own law school when he wouldn't, who secretly smiled every time she walked into the courtroom and the guard tried to usher her into the visitor's bench and she flashed her DOJ badge, and who thought it definitely cool that the FBI let her shoot an AK-47 in a silk suit so she could know which kind of weapons George Bush 41 wanted to ban. Yes, there were scary, truly scary things about this time. No more scary than the day in which Arthur Lyman was threatened with death. And they swept the room. No one in the room knew this. This was long before we had all of the protections in the Senate that we do now. But you see, terrorism began long before. In 1987, it went by the name of Abu Nidal. And he took us into the other room and asked all of the staff whether they wanted to leave, and they could, of course. He gave us all permission to leave. And no one said they would go. You just couldn't. Instead, sitting right behind him, I just ducked quicker to get those documents when he would interrogate Colonel North. And I learned a lot about lawyers and politics from that episode. And I thought I knew enough, at least, to get me started on this project, which was such an amazing opportunity. So I toddled off to the library to find out how much I could get to know in a short period of time, knowing that I stood on the shoulders of many in a shattering generation, and that to much who has been given, to those who have been given much, even accidentally, much is required. Now, the Violence Against Women Act has been criticized for many things. If one opened the National Review or the New Republic in the mid-1990s when it was passed, one will learn that the bill was drafted by radical feminists, promoted victimology, and was inspired by activists who just hate men. In 2005, Phyllis Schlafly called it the Hate Men Bill. It's gender neutral, trust me. Now, since Senator Biden and Hatch authored the bill, and they are men, one might wonder whether this hate men rhetoric was a bit overheated. Despite the name of the bill, it was gender neutral, and as we have recently seen in the Penn State scandal, rape is not a crime that only women suffer, even if we live in a society in which they are likely to be the predominant sufferers. It is a vicious attack on personality, but it does not know one physical type. Elsewhere, I have described the Senate of the 1990s in not terribly flattering terms. It was a place where there were very few women. It was plagued by sex scandals, the Packwood scandal, senators involving with their own staff, repeatedly sexually harassing their staffs. It was a place where I would write my speeches. I would occasionally have 15 minutes to write a speech on something like habeas corpus. And I would run down 2 floors, because there is no ladies' room on the floor of where the Senate meets. You run down 2 floors, and there's a lovely lounge for ladies that's quite capacious in case you'd faint from all of that activity, I guess. And I would write my speeches in there because there were no ladies, essentially. Now, so it really wasn't a place of radical feminists, as was claimed by the National Review and the New Republic. I think that really undermines the role that was played by many people, including people like Susan Bryson, in making the bill a reality. But my favorite critic, just to add a little bit of levity, wrote that the acronym VAWA, and this is a feminist, the acronym VAWA sounded like the name of an avenging female demigod. Joe Biden, avenging female demigod? No, no. In fact, there's a much more plausible dismissal of the act, that it should have been easy to pass. After all, who is for violence? The ACLU came into the Chief Counsel's office about a year after it was introduced, and they've since changed their position, but at the time, they believed that the bill was faddish and violated the First Amendment. So, why was it that it might have been hard to pass? Well, I didn't know this at the time. When I said I was naive, I really was. When I went to the library, I wrote a law. And I wrote a set of proposals, some of which became law, some of which were thrown in the trash because they were bad ideas. But we've had this problem for a long time. So we have to ask, why was there no federal legislation before this time? It's not as if this kind of violence hadn't been recognized for a very long time. You can pick up the New York Times in antebellum New York in 1856 and read of editorials on wife beating, in which the crime is reviled as a, quote, most brutal treatment of women by their husbands, in some case so vile as to be, quote, unthinkable in the Christian world. Now, unthinkable is, of course, the operative term here. For indeed, this has traditionally been one of the great stumbling blocks in addressing this violence. Any civilized person would think it unthinkable, and so it is unthought, unnoticed, denied. So if it's hard to imagine anyone praising this violence, we still have the question about why it is that it might have been difficult to pass. Now, anyone who knows the history of women in America knows that there's a very long history of second-class citizenship. At the founding, women were unable to speak in public. For almost 100 years, they were unable to own their property. They were unable to vote till the 19th Amendment, unable to sit on juries, unable to practice law, unable to serve their country in the military, and in fact merged by law in something called marital unity, merged by law into the personality, legal personality of their husband or father. It's important to remember that history, but I have to tell you that the history about violence against women is much more modern. In fact, we don't have to go back to 1856, et cetera, to learn why there was a problem with trying to pass federal legislation on these issues in 1990. Imagine the year 1979. The country's in a recession and President Carter's popularity is low. People are out of work and articles about crime bespeckle the papers. The president has promised much for many, and the many are by now disappointed. They are eyeing gas prices nervously, vowing to save money. Their anger becomes louder as the economy grows worse. A new agenda emerges, oddly at first, out of what seems entirely unrelated, but focuses on the family. And that agenda is fueled in part by women who just a few years earlier had made it their mission to stop the Equal Rights Amendment. Women like Phyllis Schlafly of the Eagle Forum and Connaught Marshner of the Free Congress Foundation would deploy their considerable political talents in fighting for the family and against those who they like to call women's libbers. Schlafly was never shy. Those libbers want to take jobs from our men in this terrible economy, she said in 1979. After all, most women would stay home if they could, if only inflation did not force them into the labor market. Yes, the year is 1979. The country's politics, once focused on the Cold War and communism, was experiencing a new and powerful force which went by the name of the family. And the family turned out to be, as it always has been, I think, throughout our history, a tremendous vessel in which to pour a great many political issues. Indeed, a vessel which, by equating that which is distant to that which is near, country with home, patriotism with love, intensifies and amplifies political passions. By 1980, fear of the economy and of government itself had been transmogrified into fear for the family. The whole point of the pro-family movement, warned Schlafly, was to, quote, get the federal government off our backs. Now, how exactly did that work? What did the family have to do with getting the government off our backs? Well, here's the logic. The federal government, quote, interferes by increasing inflation. That makes it necessary for women to leave their homes to go to work and makes them abrogate the roles they really want as wives and mothers. Then the government uses the fact that they are in the workforce to create daycare. Daycare is powerful. It has over 8,000 hours to teach beliefs and behavior. The family should be teaching values, not the government or anyone in daycare. In 1979, the ERA, however, met its legislative match. Those pro-family forces decided that they would introduce their bill, not the ERA, but something called the Family Protection Act. Now, although it has now long been forgotten, it was never passed, it was introduced by Senator Paul Laxalt before the presidential election as a wish list for a new line of groups who had fought against the ERA and were now pronouncing themselves in favor of the family. It was later reintroduced by Senator Jepsen of Iowa in 1981, and it covered a vast range of issues, from union dues to legal services to busing. Family? Of course, anyone who knows anything about legislation like this knows that drafting such a bill with that many issues means it's going to die, because it will be referred to so many committees in the House that they will never be able to agree upon a final bill. So it was a wish list of a certain intense group of people that didn't necessarily appear on the face of it to have much to do with the family. But it did include some very important provisions. I have told you that the law included things on taxes and segregation and busing, but there was an anti-equal rights amendment core. First, there was the provision on textbooks, and I have to read these because you wouldn't believe it if I didn't read it. You can find it. I brought the bill with me in case you doubt that this was actually introduced. States, on pain of losing all federal funding, were to ensure that textbooks would properly assign roles for women and men and exclude materials that would, quote, tend to denigrate, diminish, or deny the role of differences between the sexes as it has been historically understood. Sex stereotyping was not only permissible, but required in children's textbooks, lest a state lose federal funds. Second, there were provisions on playgrounds. No federal agency could deny a state funding because girls were barred from playing Little League. Sex segregation on the playground was appropriate, as the authors termed it, to prevent role confusion and Title IX extremists. Playgrounds. Third, there were provisions barring federal intervention in state laws on family relationships, and of course, various provisions that, as we will see, dealt with domestic violence. But before we get there, I just want you to see how this was all connected up in the rhetoric that was very much about a religiously inspired vision about domestic roles, about husband and wife. As the New York Times explained, the pro-family movement was a drive to reestablish the traditional domestic roles of husband as breadwinner and wife as child rearer. Paul Weyrich, who was the director of the Free Congress Foundation, put it, feminists were seeking dominance, and the only way to get rid of this was to go back to the biblically ordained nature of the family, with the father as head of the household and the mother subject to his ultimate authority. As Connie Marshner put it, life is a lot more sane and livable when you know where you stand. Women need to know where they stand, below men. Somebody will have the authority and make the decision, and women's job is just to be happy with it. Now, for our purposes, the most important thing about the Family Protection Act was that it included a title that provided that the federal government could not, under any circumstances, aim to prevent any manner, any state law, or pass its own federal law involving what was termed family violence. Now, ultimately, as I said, a bill that was just sort of an agenda setter is unlikely to pass. But on this one issue, they won. And how did they win? Well, they won by defeating the other side. That particular provision never became law. But in 1979, the issue resurfaced from the other side. California Senator Alan Cranston introduced a minor provision that would provide, originally it was authored by Barbara Mikulski when she was in the House, provide $15 million M, for the fiscal year 1981, $65 million over 3 years to battered women's shelters. By May of 1980, it was clear that the bill had become a symbol for larger forces. Opposition senators and activists wrote that the law would become a, quote, OSHA for the family. Now, they're referring to the Occupational Health and Safety Administration, a much maligned bureaucracy that governs workplace safety and is generally known as both hapless and overly regulatory. Howard Phillips, then a conservative think tank pundit, warned that family violence had to be handled as it was in the old days, by private organizations, religious groups, families. Conservative columnist James J. Kilpatrick went even further, expressing shock that the Senate would even consider such an act to prevent domestic violence, and declaring, quote, I would like to commit some. He added, a man who would strike a woman was beneath contempt, but the world is full of contemptible people. The combatants quickly translated their arguments into grander terms, covering claims we see today as obviously odd in grander terms about power and the role of government. Remember, I talked about the family as a vessel for larger claims. So just as the anti-ERA forces had translated their vision of roles, of sex roles, into a claim about government-induced inflation, remember that? Well, now we have the debate about domestic violence transformed into an argument about government. Here is Phillips again. Whenever the federal government sticks its moldy fingers in an area, it has a corrupting impact. I wonder what he'd say about things like property rights and patent law. Kilpatrick went further, blaming the entire deficit. Does this sound familiar? The entire deficit on Senator Cranston's domestic violence bill. The $15 million will simply have to be printed and added to the already mountainous deficit. Do you ever ask yourself how bureaucracy swells and deficit grows? Consider this bill. But of course, there was no federal bureaucracy. These were existing shelters. Of course, none of this was said about the Family Protection Act, which sought to restructure federal aid to education to the tune of billions of dollars. If you didn't have those textbooks, you would lose all your federal funding, and required the states to include in their textbooks historically correct sex roles. In 1981, Phyllis Schlafly testified before Congress that sexual harassment amounted to a federal case about bosses pinching secretaries, and that feminists were the true harassers, fighting motherhood and the role of the dependent wife. Far-right columnists of the day decreed that civil libertarians were beginning to show interest in granting wives the right to charge their husbands with rape. This is another surefire way to destroy the fabric of the family in the name of personal privilege. Sexual Congress was once the exclusive moral preserve of marriage. Now it appears the husband is to have exactly the same rights with regard to his wife as any bystander. By the time the Senate debated Cranston's bill, opponents were ready. Shelters, they argued on the floor of the Senate, would become havens for teenagers and others who resent family discipline. This is the floor of the Senate. The bill would, quote, dot the countryside with federally authorized hostels that double as indoctrination centers, end quote. One senator proffered an amendment limiting shelter funding to married couples to ensure that the bill was family-oriented. Senator Cranston replied in exasperation, should women fleeing in the middle of the night from their homes be required to show their marriage license before being admitted? With no hope of compromise, the majority leader had to take the bill off the floor, moving on to other legislation. Now, there were critics of this debate. The columnist Ellen Goodman explained that the pro-family forces were blaming women for breaking up the family, not the husband who beat her up. And if these senators were right, she wrote, shelters are dangerous precisely because they suggest that her husband has no right to enforce his authority with a left hook to the jaw. As she also noted, several prominent liberal senators absented themselves from this debate because they were up for re-election, and this was considered a hard vote. When the bill resurfaced in September 1980, Senator Helms led the opposition, urging that it would punish domestic unhappiness and result in federal sanctions for spanking and nagging. Helms quoted derisively the opinion of the 1978 Civil Rights Commission recommending that there were, quote, structural causal factors contributing to family violence, including the notion of the husband as the, quote, head of the family. Oddly and presciently, Senator Helms would quote from the future Chief Justice of the United States, Justice Rehnquist, in a statement that would ring forward literally through the decades and ultimately be repeated in his 1991 public statement opposing the Violence Against Women Act, and again, in his opinion, striking down part of that act in 2000. In Senator Helms's statement in 1980, he paraphrased the future chief. Mr. Justice Rehnquist spoke to the increasing intrusion into family matters by both government and the legal system, and I'm quoting Helms, quoting Rehnquist. Under the pretext, he says, of the legal system resolving ordinary family disputes. He observed that this steady imposition of adversarial laws and process upon the family has contributed to its disintegration. He concluded that the integrity and autonomy of the family are, quote, best retained by a government which provides for no intervention except in extreme cases. This is Rehnquist being quoted by Helms in 1980. The statement was doubly prescient. Justice Rehnquist not only made a similar statement about the Violence Against Women Act in 1991 in his role as the head of the Judicial Conference, he also made a similar statement in his opinion in the constitutional case which struck down the civil rights remedy, which was the most controversial piece of the original Violence Against Women Act. In that case, United States versus Morrison in 2000, he would write that the, quote, petitioner's reasoning will not limit Congress to regulating violence, but may be applied equally as well to family law and other areas of traditional state regulations, such as marriage, divorce, and childbearing. Rehnquist claimed that intervention should only be in extreme cases. What Helms had quoted in 1980 was, in fact, the truth at that time, as we now know. As Congress fought, and the antis proclaimed that this was all about the scope of government, the world was awakening to the horror of this violence. There was the story of Tracy Thurman, who called the Torrington, Connecticut police repeatedly until her husband stabbed her 13 times and broke her neck as her 3-year-old son watched and a policeman stayed in his car across the street, mid-1980s. There was the gang rape of a mother of 2 in a New Bedford bar urged on by a gang of men, later become the celebrated movie The Accused. The television actress Farrah Fawcett shed her image as Charlie's Angel to star in The Burning Bed. The story of a woman who had suffered 13 years of domestic abuse and set fire to her bed, killing her husband. A woman named Judy Norman, whose case is taught in every criminal law class in the country, because she claimed self-defense, was revealed to have been tortured by her husband, made to eat dog food, prostitute herself, sleep on the floor. And when her husband met the EMTs that were trying to save her when she tried to commit suicide, told her to let her die. They did nothing, sent her back into the house. She killed him the next day. In 1984, it was discovered that one of the original proponents of the Family Protection Act, Iowa Senator Jepsen, had visited nude dancing establishments, which he said he thought was a health spa. The scandals were beginning to emerge as well as the horror of the violence. By the end of 1984, as this kind of scandal and some of these events would emerge, the Congress would finally pass the Family Violence Protection Act as an amendment, however, to a child abuse law. But the conversation didn't die. In 1985, at an international women's conference, the president's daughter, Maureen Reagan, was forced to deny that shelters were, quote, R&R centers for bored housewives. 24 congressmen describing themselves as pro-family complained to the Attorney General about a grant given to the National Coalition Against Domestic Violence, calling the group pro-lesbian and radically feminist. Maureen Reagan broke ranks and criticized Attorney General Meese's position, but conservative opponents still insisted that the group was full of radical pro-lesbians, therefore sexualizing the issue as if that were relevant. Ultimately, a valiant victims' rights advocate inside the Justice Department, a woman named Lois Harrington, had to explain to the press that they claim shelters are anti-family, but that is not so. Abuse is anti-family. To blame shelters for the failure of marriages is like blaming firemen for arson. Now, had I known of this history, I think I would have been a little bit more afraid of what I proposed to Senator Biden. There are some virtues on occasion to naivete, and in this case, I was naive about this history. I knew nothing of it when I toddled off to the library to write my various proposals. Of course, if I had known that I was destroying the family, I never would have told my mother what I was doing. I certainly wouldn't have told Senators Biden and Hatch because they would have been worried about their large and boisterous clans. And I can now tell you that I would never have told my own children of what I was trying to do. Taken out of context, I think the Violence Against Women Act might have seemed that it was easy to pass. But the truth is that for a decade or more prior to its passage, there was a backlash. Part of that backlash included the resistance to acknowledging the existence of sexual and domestic violence. Neither liberals nor conservatives were successful in stepping up to this in any concerted manner until June of 1990, when Senator Biden introduced the Violence Against Women Act. Since then, I have wondered whether, I call them the antis because that was what those who opposed the 19th Amendment, the right to vote, were called, whether the antis who supported the Family Protection Act knew much about the history of this country. Did they know that their words might have been ripped out of a colonial statute governing slaves and women, a day in which a woman who killed her husband was guilty of treason for killing her governor? Did Phyllis Schlafly, as she attended law school, as she did, read the 1872 Bradwell case, decrying that, quote, saying women can't be lawyers? The family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. Did Connaught Marshner know that those who fought the right to vote argued that, in part, that it would destroy the family? History tells us that ideas about family and government have been linked over and over again since our very founding. And they have been linked in symbolic war between two very different visions, one of consent and equality and the other of authority and monarchy. John Locke is considered our nation's founding philosopher, for he replaced what seemed divine right with a political order based on the consent of the people. What many do not know is that he wrote that book as an explicit answer to another book. The book he was answering was written by a philosopher named Filmer, and it was an argument for monarchy based on the family, entitled Patriarcha. The father was monarch, head of household, the perfect model showing the natural order of the divine right of kings. Filmer was, by the way, no radical man-hating feminist. He was simply a radical monarchist and authoritarian. Which brings me to the ultimate question haunting the history of the Violence Against Women Act from its earliest days. Why a federal law? Whether in its funding provisions, its interstate remedies, or its most important, what I called incentive reconciliation programs. These were programs where police and advocates who had been warring were brought together. The Violence Against Women Act was a declaration that family relationships, motherhood and fatherhood, cannot define the essence of citizenship for anyone, male or female. Only the nation as a whole, not marriage or a child, can grant citizenship. One cannot simply be a citizen of Illinois or Texas or New Hampshire. We fought a bloody civil war for that. To the extent that the arguments against the Violence Against Women Act have been based on the idea that it is anti-family, its opponents have invited the very response that they decry. The more it is said that the law is only about divorce, the hate men law, and fathers who do not see children, the more it becomes necessary for those on the other side to insist that the issue is not family, it is violence, and it is right to equal citizenship. For what is the first duty of government, even the leanest night watchman state, but the protection of all citizens? When in 1979 and 1980 the antis were making their great claims for the family, we now know that America was living a lie. To be sure, there were state laws in the books about domestic violence and sexual assault in the 70s, but they were often ignored. This was America's dirty little secret, that the country had abandoned too many of these victims to a state of horrible nature. Law students now study these cases in criminal law, cases where women are prostituted, cases where police are called and nothing is done. And hopefully, and I do believe this is true, in many communities, our first responders and advocates are now on the same side when they weren't before. This was one of the great aims of the various provisions of the original Violence Against Women Act, even though one of its core provisions on equality was struck down by the Supreme Court. But the sad truth is that the antis have never really gone away. In researching this lecture, I found a newsletter dated in 2005 which called VAWA the Hate Men Law, and decried the domestic violence industry. I guess that must have been started by James J. Kilpatrick, who just wanted to commit some domestic violence. The antis talk less, as they did in the debate about ERA, about unisex bathrooms. That was a big issue in the 1970s. Childcare, daycare, big issue in the 70s. Today, they still decry the radical feminists who wrote the bill, and they still say that it's about Soviet-style psychological re-education of men and teenage boys. Now, who's looking for re-education? Remember that Family Protection Act, the one that required every state in the nation to rewrite its school books to provide for the proper historical family role of men and women? And who is it that really cares about states' rights and forced education? Now, I dedicated this lecture to Lieutenant White for a reason. If we are to believe the antis, one must fear that Ashley White Stumpf died in vain, that her value lay in her body or her family, but not in her valor. One of the greatest claims of those who opposed the ARA was that women should never serve in the military. I refuse to believe that Ashley White Stumpf died in vain. There is no higher claim to citizenship than service to your country. Since 1990, other countries have looked to America as a leader in the fight to liberate those who are oppressed by sex segregation and slavery and tyranny this country has never known. Administrations, Republican and Democrat, have since united to fight violence against women around the world. So do not let the antis tell Ashley White's parents that she did not die for her nation in a fight against the oppression of women around the world, that even the military understands is necessary to their own and our nation's defense. There are no state laws that can adequately honor that service, for she died for us all, for the nation and the world. Thank you.
For discussion, questions and answers. I'm going to keep a speakers list. Rocky has this lovely tradition of calling on the students first, so I will give them first priority.
Please use the microphone over here, I've been told. Or there's one up there too.
I was just wondering, what was the argument that the ACLU made to say that the bill violated the First Amendment?
They have since disavowed this argument. But at the time, the theory was that the civil rights remedy in the bill, which allowed a federal cause of action for one who is a victim of gender-based violence, would entail the use of speech as evidence, would require something like, I hate you women. There was a famous death in Montreal where a guy went into some engineering classroom and killed all the women and not the men and said, I hate you, blank you, feminists. So they took that case and said, well, that's the essence of what you're going to have to prove your civil rights remedy, and therefore it will chill speech. My response to that at the time is, well, now you've pretty much eradicated every federal criminal law, so I don't think that one's going to work. How do you prove homicide, for example? Well, there may be a note or something like that. So I was never convinced by that, and they've since retracted it. But Mort Halperin did follow me around quite a bit trying to convince me that it violated the First Amendment. So it's similar to the hate speech argument.
I may have missed something in your presentation, but what is the current status of the Violence Against Women bill? Is it still up for a vote at some point in the future?
Well, hopefully after the election. This is a reauthorization of the bill. So the bill's legal provisions remain in effect, and they've been amended several times. As far as funding goes, that will have to be reauthorized because otherwise law would become completely ossified. And ultimately, it will end up part of the budget reconciliation process, which is why it's been delayed. There are also some provisions in it that may be controversial, but I don't think it's the first thing that's going to come up in Congress. The first thing is the tax code. But a lot of legislation has been put on hold, a lot, awaiting for the outcome of the election. But it will come up.
My other question, I believe what happened with the ERA was that it was passed by both houses of Congress, but then the states refused to ratify it.
That's correct.
If you could repeat the history of that, which maybe some people are too young to remember.
Well, it was very close, and I don't remember the number of states. It may have even been the last state that was needed to ratify, but the forces that basically Phyllis Schlafly got a group of people and church buses to go around to state legislatures to stop the last states that were needed to ratify the bill. And there's something you need to know about how difficult it is to amend our Constitution to understand why that it's not terribly surprising that even something that had huge support in the nation, and I can't quote the polls, but at the time had a vast amount of support, could nevertheless be stopped. When Franklin Roosevelt tried to pack the court in 1937, he was asked, well, why don't we just amend the Constitution? And he said, well, if I had $10,000, I could stop any amendment stone cold. Well, how do you do that? You buy off a few state legislatures because of the difficulty and the number of states that are required to amend our Constitution, which shows why it's not been amended very much. Now, that doesn't mean that, what's interesting is this cause hasn't, while we've focused on other issues, we have not seen a tremendous effort to revive that. So I think there's a vast majority of people in the country who would probably support it.
With the new reauthorization, one of the more touchy topics is that giving tribal courts the right to, giving tribal courts like the ability to prosecute non-Native Americans on the tribal court when they do commit acts of violence against tribal women. What do you think about how that's being forestalled and basically being debated is like not letting tribes have their own sovereignty?
Well, I'm going to have to give you a non-committal answer on that because I simply am not an expert on tribal law. One of my colleagues, Richard Monette, who's actually one of the leading experts, my former colleagues at the University of Wisconsin, used to actually be a Senate staffer, and whenever the term tribe came up, I would turn to him, because my job was to understand the entire criminal code, which is kind of big, you know, 18 USC, then you add on the drug laws, and you know, you're carrying around a few hefty, you know, hundreds of laws. So I'm going to tell you I really don't have an answer for that. I do think that the tribal issues are very, can be contentious, but I don't think that's probably what would be holding it up ultimately. These things are typically worked out by experts. Those who are on the Indian Affairs Committee typically come to some resolution. But, you know, these days, I used to say that about immigration too, and that clearly is not true anymore, so I'll have to give you a non-answer. But if you want the answer, want to use my name and email, Richard Monette at the University of Wisconsin. Okay.
Can you talk about how Senator Biden went from kind of, you go off and research this, to becoming the proponent of it, such an advocate of it, and then, I mean, I don't know if it's a similar process with other senators who have embraced bills that really are difficult, and they take a lot of heat for it, being called radical, you know, feminist and all that kind of same rhetoric. There's a lot of legislation like that. So what happened to make him such a strong supporter?
Well, no one, you know, when we introduced this, I remember, I didn't even know what I was supposed to do. I remember he was mad at me because I wasn't on the floor at the right time or something, and I was trying to, you know, sort of deny the product. I had already debated it among the staff, et cetera. But it's clear everyone was like, is this going to fly? And particularly with the civil rights remedy in it. And what happened was we held hearings. So we were all, I was like, oh, well, I'm about to lose my job, you know. I'd managed to out-debate my fellow staffers, but, you know, it isn't exactly like a Supreme Court argument, so I was going to see. And we held the hearings, and it was the voices of the women, which is why I said it, and I really do, and it's not false humility. It was the voices of the women and the men who work on these issues, and particularly the women survivors, that transformed the entire Senate Judiciary Committee. And Senator Thurmond was the ranking member when this started. And Senator Thurmond was unfailingly polite to all the witnesses. I tell a story in which I had to introduce Oprah to all of the members of the Senate Judiciary Committee. She had a child abuse bill that she wanted to further, and she'd had the governor of Illinois come and testify about it. This is somewhere in the middle of this. And he was unfailingly kind, and she said to me, well, what's he gonna do? And I said, he's gonna say you look lovely today. And he did, because that's what he said to all women. But he realized he could not say that. I mean, his staff said he was really affected by this. And then Senator Biden, seeing this reaction, there was a big press reaction, there was a galvanizing moment. And then over the next 3 years, what would happen is Senator Biden would loan me to people, and they would hold hearings in their own. I was loaned to Senator Hatch to go out to Utah. And we had a hearing, and Manus Cooney, who was his chief counsel, and I sat there, and we listened to women of his church and his community look him straight in the eye and provide horrifying stories. And, you know, at the end it was funny. He tried to give me a hug. And he said, oh, I can't do that. But it was, like, that's improper, oh no. But it was clear that he was very affected by this. And this kind of thing then mushroomed to the point where Elizabeth Dole Senator Dole, who was the minority leader at the time, said, you have to do something about this now. So it mushroomed, and it was a bottom-up effort. People were hearing from their local constituents. And you know, this was not, when I asked battered women groups to tell me what they needed, they said, our second source of funding is bake sales. I said, okay, we can work on that. But they were basically what I call battered groups. They didn't come in and storm and say, I want this legislation like the credit card companies or somebody else would. Because of the prior story I told here, they thought there was never going to be any legislation. They had no idea. And who's Joe Biden? They're like, I don't know, Joe. You know, what's he doing on this? So I spent a lot of time trying to develop relationships with people who certainly knew more about the problem than I did, but were thrilled just to get any hearing about the problem. And of course, there is limited federal jurisdiction with respect to a lot of this. And so we had to work up partnerships between states and federal governments that would work. And that's out of this ground up, top down mixture came a number of provisions that basically gave incentives to force people who were seemingly on different sides of the issue to come together, such as police and advocates to work together. And many people have told me since that has been one of the most effective things that the bill ever did, to reconcile forces in the community that should, in fact, have it in their interest to fight this violence. Because if you ask any police officer, he'll tell you domestic violence, it's the most difficult call to take. So there are many shared interests, and having found those shared interests, we tried to work on federal-state partnerships to achieve that. Hope that answers the question.
Yeah, hi. My question is, I think you said that with the Violence Against Women Act, one of its core provisions was cut down by the Supreme Court. Did I miss? I don't know if I missed that. That's correct. But could you just say a little bit one about that?
In 2000, the Supreme Court struck down the civil rights remedy, the major equality piece of the Violence Against Women Act, which provided a federal remedy for individuals to go into court, and it was modeled actually on a Reconstruction era civil rights law. So I copied a law from like 1866, but nevertheless, it was struck down, and I'll have to give you a little bit of a lecture to explain why on law. There were two bases for this civil rights remedy. The Congress only has the power to do what the Constitution says it has the power to do. And the Constitution says you can regulate commerce. That came up in the health care bill. right? And it says under the 14th Amendment that no state may deprive you of equal protection of the laws. And so equal protection and commerce were the two grounds in which the Violence Against Women Act was based. The major cases, there was a hearing by constitutional experts from the University of Chicago and NYU and all of that, and they said it is constitutional. Why? Well, because the Supreme Court had decided some cases in the 1960s involving the Civil Rights Act of '64. And they had said that you can regulate private accommodations. The government can desegregate hotels and restaurants based on the commerce power. So many lawyers thought that the commerce power was almost infinite. Now, the year after the Violence Against Women Act was passed, and 2 years after I first saw this argument in a memo, I still don't know who wrote it, but Senator Biden gave it to me, and I had to answer it. But the argument was, well, commerce should only apply to economic activity. And the Supreme Court in a case called United States versus Lopez, which involved the Gun-Free Schools Act, you can't have a gun outside of school, struck that law down because it was not commerce. It's crime. It's not commerce. Once that Lopez came down, I knew the Violence Against Women Act would be struck down. Because in my opinion, I believed that the chief was sincere. And he believed that if the Violence Against Women Act were passed, the federal courts would be swamped with cases. But as Professor Price and I have been discussing in the past 2 days, there's a terrible irony about that. If you believe the problem is that bad, why would you say that you can't use the federal law to achieve it? After all, that's what we did with the 1964 Civil Rights Act, and that's what we tried to accomplish with the Reconstruction-era laws, which were not enforced. Ditto, some law professors such as Reva Siegel have identified Morrison as the new Reconstruction era of the Supreme Court. The Reconstruction era was the era where they took back all of the laws that were passed right after the Civil War, where the court viewed them so narrowly. So here's the problem. Let's say commerce doesn't work because rape isn't commerce, and you're going to narrow your focus on the particular act. Equal protection also doesn't work, which seems odd, but it doesn't work because it says, and in the Reconstruction era, they had limited the Equal Protection Clause to only actions by state. It says no state shall deprive you of equal protection. Now, the theory of the act was that states were depriving individuals of equal protection, and that this had been documented in the various hearings. But the Supreme Court chose to identify the core action here as the individual act of violence and equated it with that act of violence. And then, as I told you, made the same kind of move to suggest, well, if we open the courthouse doors to this kind of criminal activity, in the opinion, Justice Rehnquist says, well, we're going to open it up to things like divorce and child custody and things like that, which would in fact, he's absolutely right, if that were true, it would swamp the federal courts because they're a tiny part of our judiciary compared to the state courts. The problem is that the court sliced and diced the arguments, in my view, and I've argued this in the law reviews before, which is when commerce is attached to equal protection, there should be a stronger argument. When students like Christy Brancala, who brought that case, had to drop out of school because she was raped, because they did nothing they made no accommodation for her in light of the aggression. When she lost out on opportunities, she lost money. She may have lost various careers. And so it seems to me wrong to think that, well, if you open it up to this case, then you're going to have to decide every criminal case. That's not true. It would only be criminal cases that involved equal protection. But the court never considered that argument. The intersection of equal protection and commerce has always been look at the '64 Civil Rights Act, a core place where you should intervene, where we should have equal protection, because commerce is the great engine of our economy, right? And if this violence is in some ways diminishing women's opportunities to take particular jobs, which was the argument, to have education in certain places, then it seems to me that Congress does in fact have the authority, and then what one does not have to believe that Congress can pass any law about family, custody disputes or things like that. That the slippery slope he identified is inaccurate.
Hi, thank you so much for all your work and your passion on this. It's quite inspiring. I work internationally on women's rights, and what we're seeing is the same kind of backlash everywhere. And women began seeing it around the UN conventions, around CEDAW, and the kind of backlash that occurred there, which is essentially the Convention on the Elimination of Discrimination Against Women. And one of the conclusions that some of the activists are making, and I wonder what you think about this, is that all the energies of women's movements around the world were directed toward that visible power of getting that convention passed, or in the case of the Violence Against Women Act, getting that act passed. But in doing that, they gave short shrift to all the organizing work that they had done before. The organizing work that would allow women's movements then to sustain the kind of work that had to be done over time just to confront the inevitability of backlash. Because people would organize, but then they would forget, oh, we're going to get backlash. And so it's like the penny dropped for a lot of these women saying, we didn't take this into consideration, and we have to going forward, because this is going to be inevitable. And the cycles are going to just be like this. So we always have to be prepared.
Well, there's always the problem that, law is a very crude tool. I mean, Brown versus Board of Education certainly didn't eradicate discrimination in the United States. But it can be an important expressive tool, and it can work both ways. I mean, one of the good things that came out of this was that there was an office, hopefully that will remain, within the Justice Department, the Office of Violence Against Women, to try and institutionalize a federal presence so it wouldn't, this was a very important piece that no one, really knew how important it was to keep up the maintenance of various interest groups, okay? So to continue to support the service providers in their fight over long periods of time. Because it's an odd organizational, it doesn't really fit within the Department of Justice in some ways. But it was easier because that way the Senate Judiciary Committee could have control over it as opposed to other committees. I do sense, however, that there is an odd dynamic dance that happens from the late 40s and 50s on, where there's two steps forward, one step back, and that there is a funny resonance between some of the bizarre arguments, and I really think most people think that they're bizarre, about rape being biologically impossible in certain cases, like Senator Reagan, et cetera, which I think both parties think is off the table. And I do find that odd that this is coming at this moment, but if you look back at the Carter era, you see, well, yes, we were in an economic depression. We know domestic violence tends to increase in these periods. We know that people are worried about their families, and we know how easy it is to translate these issues into family issues. So I agree with you that you always have to be prepared for the people who are not necessarily on the front lines. I think the service providers have been given some institutional support, not perhaps enough, but you always have to, you can't say we'll get CEDAW and things will be better. Even if we had passed the Civil Rights Remedy, in my opinion, the problem would have been too little help, not too much. Because the courts at the time, if they were hostile, they were going to narrow that as well. So, all the evidence we had was there were 100 cases or something by the time, for over 10 years or 6 years, I don't know. There weren't many cases. So I agree that the vast majority of sort of the bystander population who assumes a certain equality constantly has to be reminded that there have been movements of the recent past that truly called that equality and believed that that equality was dangerous to the country, dangerous to the family, and would fight for it.
Can you say more about why there were only about 100 cases between 1994 and 2000 that invoked the civil rights remedy?
Yeah, let me just say, I don't know if that there were even that many. That's because, first of all, it takes a while for lawyers to be educated about the existence of a law or an argument. I have several equal protection arguments I might make these days, but I might have them in the head, but how do the lawyers who actually get the cases have them, right? They have to be disseminated somehow. Courts did view it as very narrow. You had to have something that really kind of had the aura of a hate crime rather than simply as if it isn't a hate crime, but there were rapes and then there was rape plus, right? And this also happened with the early sex discrimination laws. Same thing happened before the courts and the EEOC moved in with sexual harassment law. When they first got the law, they did something like, sort of sex plus, right? And the same thing was happening with the early cases, and so they were fairly difficult to show this rape plus, and therefore, or domestic violence plus. And so lawyers were not taking them. It looked harder than to sue under some, perhaps, tort suit. Now, of course, there was an interesting reverberating effect, which is there were more tort suits then, which was a good thing. I mean, the state laws were not being invoked because no one was thinking of it in these terms. So there was probably some filtering effect, and some states have passed many VAWAs, many civil rights remedies and hate crimes laws that are used in some cases. What we were hoping for was something like the development in sexual harassment law, though. When sexual harassment law, when Title VII first got into the courts, it was viewed very narrowly, but over time with the intervention of the EEOC, and we were hoping with the intervention of the Office of Violence Against Women, that there would be a dialogue between the advocates and the courts in a way that would enrich the law of what it was to discriminate with in the context of violence. And it was shut down. So there were attempts to pass another version. I think at this point, that doesn't seem like it's on anyone's top piece of agenda. Basically, the administration, both the Bush 43 administration and the Obama administration, have done a pretty good job with going overseas. When you can't get Congress to do anything, you go abroad. And, they have done some, very powerful things abroad. My only concern is that we used to really be the leader. I mean, I was sent off to so many international conferences when we had the civil rights remedy because people were beginning to use the discourse of human rights, and that catalyzed an enormous set of groups that had never been concerned with these issues and still does to these days. For all the women in the room who know about the Gonzalez case, that's a perfect example of this. This is a case that went up to the Supreme Court. It's a domestic violence case. Police did not respond. Supreme Court rejected her claim. She went to the Inter-American Court, and the Inter-American Court said the United States was violating her human rights. So now forget about being the leader, we're a violator. And this is a real problem, it seems to me. So that while administrations of goodwill of both parties have done many things abroad, we still have not kept our own home front, perhaps as safe as we would like it to believe it is. And we certainly have lost the leadership role, I think, within the country.
Just following up on that. Thank you. It seems to me, too, though, that the U.S., at least geopolitically, I'm not saying in action, but in a geopolitical discursive sense, holds a higher standard for these issues internationally when it behooves the U.S. geopolitically, where it does not want any reflection back on what's happening with women within the U.S. I mean, I know that's a big sort of, we could debate that, but it seems to be what's happening, at least.
Yeah, I mean, I think that there is a lot of truth to the notion of convergence, which is the sense that when it's in the United States' interest to do this, then it's fine. When we can view it as some other people who are doing this dangerous thing, then it's fine. But it's not us. Right, we are the good guys, and you are the, primitive, sex segregators or whatever. You could see this in the sex slavery and the prostitution debates during the Bush administration, for example. Once it gets into whether prostitution is actually a real problem in and of itself, then the administration stops, right? So I think there is a good degree to that. Because one would hope that the international, that there would be a reverberating effect back. I don't see that. In fact, what I see, unfortunately, I was mentioning this, I think, to either you or Professor Bryson, I see these reports out of the Office of Violence Against Women, and they sound very much like the reports that I would write in 1990 in terms of the stereotypes that you find in certain areas of certain cases. They tend to be more in rural areas. They tend to be more perhaps the numbers are less, but the stereotypes remain. And that is very disturbing to me. But it's consistent with the story I've told here, which there are intense, passionate feelings of resistance to this because it appears to people, emphasis on appears, to invade something very sacred called the family. And people don't stop to think, really, about what they're talking about in these. It's a sort of fast reaction, not a slow critical thinking about what is really going on. So yeah, it would have been helpful. And I mean, I don't see the United States Supreme Court doing a darn thing about Jessica Gonzalez's case, for example, that her human rights were violated. She can't enforce that. And I'm sure, given their opinion on foreign law, that they think that it's not something they should pay any attention to.
I just have a comment, and I thank you with my heart and soul for your work. I am doing a lot of research work myself on this subject, but I'm curious as to why the emphasis is on primarily on women. And I see young men, and I'm pleased by that. But it seems that our culture is so patriarchal in mind, body, and spirit that changes are not going to happen unless men like Joe Biden, Senator Hatch, these individuals, unless they are able to say, we need to share this, as in everything, power, decisions, policy making, I don't see any of this changing. And I see this slip. I see us coming back to the 50s, and I talk to young women, and I think, we're not even out of it. We're not even out of it. We're going so far back, and yet I don't think that people understand that. It's that slippery slope that you keep talking about. So I thank you, and I catch my breath, but I'd like to see this more of a holistic approach.
I agree with you. I mean, it was radical in 1990 to say this was a human rights issue, which I did say at several international meetings, right? But it would have been radical to say it on the floor of the Senate. It seemed better. What?
It's radical now.
Well, it seemed better to, and I think this is there was a patriarchal part of this, calling it, violence against women, because of course, as an appellate lawyer, as a constitutional lawyer, I knew that I had to make it all the provisions were gender neutral. There were cases that were brought by men under the civil rights remedy, for example. It would have been unconstitutional. In fact, all of the early sex discrimination precedents, by the way, were all done by men. For example, the man who wanted to be the nurse, all of the early sex discrimination cases decided by the Supreme Court were brought by men. So, I have always believed that this has to be shared. And one of the interesting things, and maybe hopeful things about the international movement, is that a human rights discourse allows you to get over that hurdle of using the word woman and thinking there's some, you know, repeating inadvertently the inferiority or hierarchy. And I think, though, in 1990, given everything that had gone on before, I can see why, although I didn't think of it as the feminist cry of a demigod or whatever Hannah Rosen called it. You know, I think it was important in an empowering way. Dr. Biden, in fact, asked about this when we were first working on the bill, because she was very concerned that women might feel patronized. And of course, this is the vice president's wife. And of course, this is something we debated among the staff. I mean, this is the terrible coin. It's whether something is empowering or patronizing in these circumstances. And so it had to be done using the voices. Most of the speeches that I wrote, you know, half of them, the vice president would throw in the trash saying, "Oh, that's too smart. No one would think I would say that." True. But a lot of them would simply be quotes of the survivors, because he understood very well that as a man, he had the power to do this, but that he did not want to seem patronizing. And so we talked about this at length, about how difficult kind of a line we were treading at the time. That disappeared over a while just because we had the hearings. It appeared that there was bipartisan support, and then the Chief Justice came out of the woodwork, and then it was two titans of Washington power going at each other. So it kind of, we got over our initial concern, but it remains a deep problem. And why it's hard for me, I kind of choke a little bit when I look at the name of the act today. And, you know, I'm hoping that, you know, one good piece of good news here, it isn't as if it was, you know, we get the right to vote in 1920 and then we get on juries in 1960. Okay, that's 40 years. I mean, between the 1979 and the, it was 1985 that we got the first domestic violence, then 1990, so it's moving faster. Now, the one fear I have is that some of the recent remarks have truly been backlash of an order I truly don't even understand. I mean, not even 1950s. The bit about biologically incapable of being raped is an argument that was used by 19th century courts. So there is something very disturbing about that, and the other comments that are being made. But there's always been people who are willing to say that these issues are radical, that they'll destroy the family, that they're not human rights issues.
We have time for one more question in the back.
Thank you so much for speaking. I don't know which way I'm going to go right now, but hopefully it'll be short. I also had a reaction to that, not right away, but over time, and it probably helped me become more radically aware, but like the violence against, just the word violence against women, I began to see it as another camouflage term for male violence. Just like women's rights crisis, violent crime crisis, sexual abuse crisis, terrorism crisis, what's predominantly male violence, is just continually renamed home invasion, rape, just endless carjacking, cop killing. And I document the news and the media, how it uses language. And so I just started you can just pull, frequently hundreds of those phrases, terms out of our newspapers. So there's this language that is flooding the media, and it's just like, it's almost like the whole language, like domestic violence is just another word, you know what I mean? And if it's predominantly male violence, to turn around and really say it. Because like right now, for instance, every presidential thing, it always turns into an attack on women. That's like, it's chronic. It's the tool, whether it's in this country or whether it's another country. And it's like, that really is never really discussed. And, but I think there is an awareness always going on. You know, just even when you're talking about foreign policy in other countries and that stuff's not national, like, we're hearing what's going on right now. Everybody's hearing it. Things are moving. It is, you know, but at the same time, it's scary to have so much of our media time and our people running for president of our country, and just whether they're male or female, talking the way they've been talking for the last few years. But anyway, I'd just like to thank you very much.
Well, I do think that language is important, and I think that we do need to pay attention to it. And I do think the human rights frame is actually a very powerful one to switch to. Now, I will tell you that I think I think you're doing a great job trying to look at the media framing, because they tend to focus on certain things, and we don't pay any attention. By doing this history, for example, runaway wives, that was a big term in this debate. Runaway wife? Well, where did that come from? Okay. I mean, it does change over time, but that came from runaway teenagers. The equation was, you know, in the 70s, there were teenagers who were running away, I guess, and that was a big problem. So now battered women were runaway wives. You have to pay attention and call attention to this kind of discourse, because now in history, you know, with some hindsight, we can all look at it and what's that? You know, we can't even remember it. The good news is that some of this seems so outrageous of the recent kind, it has had its own backlash, let's say, and reminded us of the more subtle framings that you're focusing on, and I think you're right to do that.
Thank you very much.